Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Welcome back to the podcast channel for groots.com.au. Thank you for listening. And we're now into part 2 of Power of Attorney with Max Williams. Welcome back, Max.
Thanks, Tony. Good to be back.
And what we're referring to is disputes over power of attorney. And I thought, well, there's one that's incredibly well known, and it's got some publicity happening again, which is the guardianship / power of attorney with Britney Spears and her father. And in the previous episode, you said there's a couple of things you need to think about when you pick someone to be your power of attorney. One is who you can trust. If you can't trust your parents, then who can you trust? Another one, qualified. He was a show business accountant by trade. And that just shows that it can be a tricky thing to do.
Well, that's a good example, Tony. I must confess I don't know all the ins and outs of that case, and I'm certainly not familiar with the US conservatorship and guardianship regime. But nonetheless, I think it is an interesting case to bring up that does highlight the importance of taking that decision into your own hands and appointing someone that you would want to make decisions for you if you lost capacity. In that case, I think it was actually the tribunal or the relevant court that appointed Britney Spears' father as the conservator or in that guardianship. Perhaps if Britney Spears had have made her own power of attorney or, enduring guardianship, whatever the equivalent document is over there, maybe that wouldn't have taken place. But it also does highlight that once someone is in that role, whether they're appointed by a court or whether you've appointed them, once you've lost capacity, it can be very difficult to get them out of that role because either you've lost capacity and therefore you're not able to do it yourself, or sometimes if they've done the wrong thing, by the time it's discovered and you try and take some legal action, it's a bit like closing the stable door after the horse has bolted. Once they've done the wrong thing, sometimes it's not always possible to remedy it or, bring things back to the way they were.
Yeah. So what I'm curious about is that in that instance, in any instance, is it worth or can you appoint multiple attorneys?
Yeah, good question, Tony. You can. The thing you need to consider when you are appointing multiple attorneys is how you would like them to operate. And whether that's going to be together or successively. So often when we see couples, they'll usually appoint each other as their respective attorneys in the first instance, but we usually recommend they appoint one or more people as backups because you never know. They both might be in an accident, for example, and lose capacity. You just don't know. So I think at the very least it's good to appoint a successor, but if you're going to have multiple attorneys who are acting at the same time, you need to give some thought as to whether they're going to be making decisions unanimously, what we would call a joint appointment, or instead, if they're going to be deciding things severally, call that a joint and several appointment. If they are going to be making decisions severally, perhaps think about how they are to communicate with each other and, in fact, whether they are likely to communicate with each other. Sometimes in families, you might have the children of a respective couple appointed as the substitutes. But if they don't get along or they never speak to each other, well, I have to tell clients that's probably not going to work because they need to be able to work together in terms of what's in the best interests of mum or dad. So, yes, you can appoint more than one, but you do need to, again, this is why seeing a solicitor is really important, make sure it's structured in the right way that's going to work.
So in that instance, would it be advisable to appoint a solicitor with the power of attorney?
Well, the short answer is no, Tony. One of the main reasons is that usually a solicitor will want to charge money for doing that, whereas most attorneys you appoint, if they're a family or a friend, won't charge money. So just purely from a cost perspective, I don't think that's a good idea. On very rare occasions, we might agree to be appointed, but that's usually where there is absolutely no one else in the client's life. Otherwise, a close family member, close friend is almost always preferable.
So in the past, we've been discussing about beneficiaries in wills. And if we talk about power of attorney, would you appoint one of them as a power of attorney?
Well, in most cases, the person you appoint as your attorney is probably also a beneficiary of your will, just because of the nature of families. There's no necessary nexus between the two roles. Though, since you bring up beneficiaries in wills, another consideration is whether you would want the attorneys to see a copy of your will if they're acting as your attorney, because there may be certain things in your will that they should know about and will help guide their decision making, because some people find this hard to believe, but an attorney cannot make a will for you. So if you lose capacity, one of the specific matters that are excluded from their decision making is making a will for the principal. And for that reason, most attorneys by law can't actually obtain a copy of their principal's will. So that's another thing you might want to consider.
Okay. So, Max, we were talking at the beginning about Britney Spears and dispute with her father. And as you suggested, it was an appointment that her father would take care of things. It seemed like a logical choice at the time. But then it led to all sorts of disputes. So how can you resolve disputes about power of attorney that someone's been appointed in that position?
Yeah, and most of the disputes we see are usually between siblings. So where one sibling is appointed as mum or dad's attorney and the other sibling isn't, and the person who isn't appointed is concerned that the attorney is doing the wrong thing, either because there's no communication or what's being communicated is very alarming. Now, in those cases, really your only resolution, if you can't resolve it obviously between the parties themselves, is to apply to the state tribunal and they can intervene. Now, sometimes that might mean if the tribunal doesn't think the relevant parties and stakeholders are going to get along, they might just put it in the hands of the public trustee, or the New South Wales trustee and guardian, as they're called here. Now, that would be quite an extreme case, but that's really your recourse. If you think an attorney isn't doing the right thing, if you've got standing, you can apply to the tribunal. The attorney may be called upon to produce accounts to show what are they doing with, mum or dad's money if it's the parent who's the principal. And then the tribunal can intervene. Now, the tribunal may say, good job, attorney, you're doing the right thing. We're not going to interfere. We'll let things keep ticking along. Or the tribunal might say, no, you're doing the wrong thing. You're coming out and we're going to put someone else in, which might be the other sibling, or again, it might be the relevant public trustee.
Yeah, okay. Look, thankfully, that seems less problematic than what we've been discussing before about that person that had to fight, different lawyers and money.
And of course, that was a high-profile case, and I think that probably factored into it as well. There's a lot of public interest.
So, Max, thanks for covering that off. And can you give us a quick little wrap-up?
Sure, Tony. So, as I said in the last episode, a power of attorney is a very important document. It's a very powerful document. And so you want to make sure the persons you're appointing are going to do the right thing. Because if they don't, it can lead to disputes. If you, on the other hand, are concerned about how a certain attorney is acting and you think they're not acting in the best interests of the principal, because that is their primary duty, an attorney has to act in what is the best interest of the principal, not themselves, not other people. That would be a conflict of interest. They have to act in the interest of the principal. And so if you're concerned that they're not, then you should seek legal advice and perhaps apply to the tribunal for intervention.
Great. Thank you very much.
Thanks, Tony. Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website, www.degroots.com.au, and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.